One of the things that we've found especially useful in the financial services industry is the strict regulatory compliance that we have and how we see privacy catching up somewhat to other compliance functions. And just as a show of hands, how many attorneys do I have in the room here? Ooh, this is going to be fun. Okay, lots of attorneys. So how many are actually like practically owning or running or participating in a privacy program in-house? Okay, all right, fair enough. All right. So I think the reason we've got so many attorneys in the room when you look at privacy compliance versus other regulatory compliance is because traditionally privacy has been squishy. And so any presentation that starts with a sponge has got to be awesome. So you guys are going to be blown away by this. So, and there's so many analogies you can use the sponge for. I use the sponge for a data analogy because we all just suck up data and the sponge keeps getting bigger and no one ever wrings the sponge out. But in this case, we're using the sponge analogy for structure. And traditionally, privacy regulations have been different. They've been squishy, they've been malleable, they've been moving. And so I think that with the advent of kind of the global standardization to a certain degree in privacy regulations, and certainly with some of the specific information management portions of GDPR, we're starting to see privacy regulations becoming a little bit more structured. And I was very glad to hear Liz talking yesterday about the singularity that's going to come when global nirvana for privacy starts occurring and everyone's running off the same systems, no more model contracts, everyone can transfer data freely across the known universe, which clearly won't happen, but it is moving in that direction. And I think that GDPR has taken some stuff from some US regulations, and then vice versa. There's some US regulations that are taking stuff back from GDPR. So we're certainly seeing a lot of kind of conformality coming in this space. So as privacy gets less squishy, what does that mean from a privacy perspective? And I think that the PIA discussion we just had is an interesting one, because I would have said in many of these cases, your privacy attorneys shouldn't be involved in a lot of those questions in the first place. You should have had governance structures in place to enable people to make the decision before it came to the attorneys, leaving only the real edge cases that need that kind of serious attention, because the way that privacy is structured today is non-scalable. And if you look at GDPR, and you look at the privacy threshold assessments, the PIAs that you're going to be running, and by the way, that was one thing that was missing from the PIA thing is the PTA, and knowing whether you need to do a PIA or not. You can't have an expert in every room, in every meeting, for every product, for every change. It's just not scalable. And so the question will come, which is, why, for all of my regulatory compliance, why is 50% of it just for privacy? And I think in the legal department, and I think that is a question that's going to come up quickly, and people are going to realize that they're going to need a governance framework.